Welcome. In this video, we're going to continue dealing with the GATT WTO regime of trade in goods, and today we're going to look at the principle of national treatment. Now, the principle of national treatment is enshrined in Article 3 of the GATT. The structure of Article 3 is set in terms of a general principle, Article 3, paragraph 1, which states that all the measures covered by paragraphs 2 and 4 of Article 3 shall not be applied so as to afford protection to domestic production. But then this general principle is made specific through paragraphs 2 and 4. Paragraph 2, as we will see, deals with internal taxes and other internal charges, and paragraph 4 deals with laws, regulations, and other measures concerning the put on sale, the sale, transportation, and use of goods. Now, before we go on, let me just say that there are other aspects of Article 3 that you need to take into account. First of all, there's Article 3, paragraph 5, that deals with so-called local content requirements. Article 3, paragraph 8, proviso A, that mentions government procurement, albeit with the intent to exclude it from the scope of Article 3, as well as proviso B, that deals with subsidies, also to exclude subsidies from the scope of Article 3. Now, note that subsidies are also subject of other provisions of the GATT, as well as the 1994 SCM agreement, that is the Subsidies and Countermeasures Agreement, and that public procurement is subject to a plurilateral agreement, the 1994 Agreement on Government Procurement, that has been replaced by the 2011 Agreement on Public Procurement. Finally, Article 3, paragraph 9 deals with maximum price controls, and Article 3, paragraph 10 deals with screen quotas for movies, which is really not a case of trade in goods, but rather trade in services, although physical goods were involved because copies of films were goods in the sense that they were incorporated in a material form. Now, what is the object and purpose of Article 3? The appellate body has issued throughout its jurisprudence a number of pronouncements describing what the object and purpose of Article 3 is. And here you have, in the slide, we have a number of statements by the appellate body to the effect that the overall purpose of Article 3 is really to avoid protectionism as to the application of internal measures, both taxation measures and other regulatory measures, and that the objective is also to ensure equality of conditions of competition between imported and domestic products. And so this doesn't mean that members will be prevented from pursuing other goals through internal taxation and regulatory measures. It simply means that members will have to ensure that such measures are compliant with the principles of Article 3, particularly paragraphs 2 and 4. Now, the scope of Article 3 is not limited to products where concessions have been made. So unlike what we saw in Article 2, whereby the treatment no less favorable than is established vis-a-vis products where members have made concessions, Article 3 applies across the board. So all goods, whether or not there have been concessions made, are subject to the principle of national treatment, and therefore the equality of conditions of competition is something that is protected by Article 3 regarding all types of goods, again, whether or not there have been any concessions. Now, let's look at Article 3, paragraph 2. Now, Article 3, paragraph 2 has two sentences, and there's a different legal regime depending on whether a certain measure is to be assessed under the first or the second sentence. Now, starting with the first sentence, as you can see here, this first sentence is aimed at ensuring that imported products are not subject, either directly or indirectly, to internal taxes or other internal charges of any kind in excess of those that are applied directly or indirectly to like domestic products. So here we have some of the key elements of this provision. Now, the second sentence, on the other hand, has a broader scope in the sense that it's, as it states, moreover, so in addition to the protection afforded by the first sentence, no contracting party shall otherwise apply internal taxes or other internal charges to imported or domestic products in a manner contrary to the principles that are set forth in paragraph 1. Now, as we know, the principle set forth in paragraph 1 is that these measures shall not be applied so as to afford protection to domestic production. But what does that actually mean? Well, in order to interpret the meaning of the second sentence, we have to look at the note of Article 3, paragraph 2, that is also part of the GATT 47 and now the GATT 94. And as you can see in the text of the note, a tax that conforms to the requirements of the first sentence may nevertheless be considered incompatible with the second sentence, but only in cases where competition was involved between, on the one hand, the taxed product and, on the other hand, a directly competitive or substitutable product which was not similarly taxed. Now, this means that, in the view of the appellate body, the second sentence involves a three-tier test. First, are these imported and domestic products directly competitive or substitutable products that are in a competitive relationship with one another? Second, are these imported products and directly competitive or substitutable domestic products not similarly taxed? And third is that dissimilar taxation applied so as to afford protection to domestic production. Remember, this is the principle that we find in Article 3, paragraph 1. Now, there are differences between these two sentences in the sense that Article 3, paragraph 2 has a narrower scope as it envisages only competitive relationships between like products. But on the other hand, the legal rule is much stricter for countries applying internal charges because the test is whether or not the imported products were subject to taxation in excess of that which is charged to domestic like products. Whereas the second sentence has a much broader scope in the sense that it does not limit itself to like products or to that type of competitive relationship. It covers a relationship of direct competition or substitutability between these products. But on the other hand, the rule is now more lenient towards members applying internal measures, internal taxation, as it requires now that these different products be not similarly taxed, and in addition, that this dissimilarity in terms of taxation will afford protection to domestic production. And so we have two different legal regimes depending on whether we fall under the first sentence or the second sentence. Now, one of the questions this raises is, what are like products? Now, the sort of starting point for looking at the issue of substitutability and of likeness is a working party report on border tax adjustments that was approved in 1970 by the contracting parties and therefore is part of the GATT acquis under the WTO agreement. And in this report, the members pointed out to a number of criteria that could be used in a way to identify this type of likeness between two products. Now, the working party did advise, and this is something that has been taken up by by the jurisprudence of the appellate body, that this is always a case-by-case analysis. So it is not possible to simply postulate a general concept of a like product and then try to apply that definition on each case. And so this criteria method is a more open-ended one that provides flexibility to decision makers. Now, the appellate body has adopted these criteria, and it has presented them, as you can see here, looking at the end uses in a given market, the consumers' tastes and habits, although these may change over time and from country to country, the product's characteristics, their nature and quality, and finally the criterion of customs classification. Because we're dealing with a trade agreement, customs classifications may be important in understanding whether or not members have viewed two products as being like products, or at least having a competitive relationship between them. So the appellate body in the Japan taxes on alcoholic beverages case in 1996 clearly stated that this is not a matter of precise science, that there's always some discretion involved whenever we adjudicate a case involving the concept of likeness. On the other hand, it has also stated that there's no one-type approach, so we need to look at the different criteria and evaluate what conclusions can we draw in a specific case from a global analysis of these criteria. So we cannot simply say, well, under this criteria, these are like products, and that's the end of the inquiry. We need to consider all these criteria in order to reach a conclusion. Now, another important image used by the appellate body is this idea of the accordion. This is important because, as we're going to see, the concept of like products appears to have different geometries depending on the provisions we're interpreting. For instance, GATT Article 1, MFN, only covers discrimination between like products. Article 3, Paragraph 2, on the other hand, as we saw in these two sentences, covers not only like products in a narrow sense, but also directly competitive and substitutable products as being the basis for a comparison of treatment and a possible breach of the principle of national treatment. Article 3, Paragraph 4, on the other hand, uses only the concept of likeness. And so the appellate body has developed this image of the accordion in the sense that in some provisions we're going to end up with a very narrow concept of likeness, such as the case of GATT Article 3, Paragraph 2, first sentence, whereas in others the accordion will stretch and thus encompass more competitive relations, and so the concept of likeness will be broader than when it is used in that narrow form as in the first sentence of Article 3, Paragraph 2. So we can represent this in an image by saying that we have a set of products that have a competitive relationship, products that are directly competitive or substitutable products, and that's the scope of the second sentence of Article 3, Paragraph 2. And then we have a subset of those products that have a more close connection, a more close competitive relation, and those will be considered like products for the purposes of the first sentence of Article 3, Paragraph 2. Now, obviously, the closer the competitive relation, the more likely that these products will fall under the like product subset rather than the overall set of directly competitive or substitutable products. Okay, let me give you an example of what is meant by like products. Here we're going to consider the case of Mexico taxes on soft drinks, 2006 panel report. Now, in this case, the United States applied different internal levels of taxation on soft drinks, depending on whether or not they were using the type of product they used as a sweetener. So if soft drinks used sugar, beet sugar or cane sugar, they were subject to one level of taxation. On the other hand, if they used high fructose corn syrup, HFCS, then they were subject to a different level of taxation. Now, not surprisingly, soft drinks made in the United States typically use HFCS as a sweetener, whereas in Mexico, soft drinks will use locally produced sugar, that is cane sugar. So the issue was, are these like products for the purposes of Article 3, Paragraph 2? Now, the panel found that beet sugar and cane sugar were like products, in the sense that there's a very close proximity, very close competitive relation between these two products. But on the other hand, although corn syrup is a product, as a sweetener that is obtained in a very different way from very different plants, etc., the purposes, the end uses were the same, and so they were directly competitive or substitutable with sugar as a sweetener for soft drinks. And so the panel found that there was a competitive relationship, and that therefore these products were caught by, or this differentiation was caught under Article 3, Paragraph 2, second sentence, as there was a direct competitive relationship between soft drinks using sugar and soft drinks using high fructose corn syrup as sweeteners. Let's move on now to Article 3, Paragraph 4. Article 3, Paragraph 4 covers a broad set of measures, as you can see from the drafting of this provision. It covers all laws, regulations, and requirements that affect the internal sale, offering for sale, purchase, transportation, distribution, or use of goods. And then it provides that imported products should be given no less favorable treatment than the one that is accorded to like products of national origin. So here we only have a concept of likeness. Now, as you will understand from what I mentioned earlier, this means that this concept has to be interpreted in a wider sense than the narrow concept of likeness for the purposes of the first sentence of Article 3, Paragraph 2. The appellate body has not really ruled whether or not the concept of likeness under Article 3, Paragraph 4 expands all the way to include all the directly competitive or substitutable products, but it's quite clear that, even if there's no precise match, the frontiers of these concepts will largely coincide. So, what are the specific questions we need to take into account in Article 3, Paragraph 4? Well, first of all, we need to consider the concept of the different types of measures. These measures have to be attributable to a state, and here I recall the importance of the Japan Semiconductors case, a pre-WTO case. Second, we need to look at the scope of the concept of discrimination. The treatment has to be less favorable than the one that is accorded to domestic products, and we need to know whether or not these are like products for the comparison to be valid. Now, we also need to take into account the fact that this interpretation of Article 3, Paragraph 4, as well as the interpretation of Article 3, Paragraph 2, is also connected to the issue of general exceptions, which is something that I will cover in a different video on the respective chapter. So bye for now, and I'll see you in class.